This is a case of alleged pregnancy discrimination. Therefore, we will be looking at the Pregnancy Discrimination Act of 1978 and its implied meaning. This case was reviewed by lower courts and then finally brought before the Supreme Court of the United States in 2014. The plaintiff, Peggy Young, was employed at UPS as a package courier driver. When Miss Young became pregnant, her doctor limited her from carrying or picking up bundles over 20 pounds during the first 20 weeks of pregnancy, and then only 10 pounds starting at 21 weeks of pregnancy. UPS notified Miss Young that she would not be able to fulfill her duties since the corporation mandated that drivers in her position must be able to pick up and handle packages weighing up to 70 pounds. Miss Young claims that her fellow co-workers were willing to assist her in her lifting responsibilities, but UPS consequently put Young on leave without pay, and then later her company medical insurance was terminated. The Pregnancy Discrimination Act modified Title VII of the Civil Rights Act of 1964 to shed light on Title VII's ban of gender prejudice on the foundation of pregnancy, childbirth, and any related medical conditions. The Pregnancy Discrimination Act is actually quite vital to Peggy Young's lawsuit. It insists that companies consider pregnant women the same for all employment-related purposes as other persons not so affected by pregnancy, but similar in their ability or their inability to work. The Supreme Court's verdict in Young v. UPS interprets the Pregnancy Discrimination Act clause. The lawsuit scrutinized the proper understanding and the application of the Pregnancy Discrimination Act of 1978. The second section of this act declares that women marked by pregnancy have to be measured the same for all employment-related purposes as other persons not so affected but similar in their ability or their inability to work. The PDA concentrates on prohibiting sex partiality and tolerance for pregnancy, childbirth, or related medical conditions. UPS contends that the PDA does not necessitate special treatment for pregnant women. Therefore, if they had obliged to Miss Young's request about lifting limitations, then they would be on the passage of the PDA that expresses that pregnancy has to be preserved in a similar way as the other employees that also had lifting boundaries. The court should consider opinion analysis, fashioning a remedy for pregnancy bias, argument analysis as compared to what other conditions, and an argument preview, pregnancy and workplace equality. You'll see that the court did remand this case back to the Court of Appeals to reconsider the outline founded on the 6-3 decision. The defendant, Ms. Young's employer, UPS, said no to the request accommodations and put her on leave. Ms. Young gave evidence that UPS made accommodations for other employees in the past. For instance, UPS does accommodate drivers who were injured on the job, drivers who lost their Department of Transportation certifications, and drivers who suffered from a disability under the Americans with Disabilities Act. Ms. Young claimed that the corporation, UPS, made accommodations for a large percentage of non-pregnant workers by allowing lifting restrictions while still forsaking to adjust lifting limits for pregnant workers. Any procedure that stipulates modifications or light duty to a particular group of workers but not to pregnant women will probably be found guilty of inflicting a heavier burden on the pregnant women. The court cautioned UPS for the reason for levying such a heavy burden on the pregnant workers. The court said that normally you cannot consist of simply a claim that it is more expensive or less convenient to add pregnant workers to the category of those who you will be willing to accommodate. The fact that UPS was giving some employees accommodations tends to show that this employer does not have good justification or cause for not accommodating pregnant women. UPS reasoned that this choice not to offer the accommodations was so that they could adhere to the company guidelines that did not allow for pregnancy consideration, that they did not think of pregnancy as an ailment or a disability. The appeals court called the company's accommodations policy for other workers pregnancy blind. There is evidence that providing pregnancy accommodations is good for business. It reduces employee turnover and absenteeism and boosts employee morale and productivity. As a matter of fact, during the course of this lawsuit, UPS voluntarily changed its accommodation policy to include pregnant employees, but still maintained during the lawsuit that it was not required to do so by law. Frankly, if UPS had simply accommodated Ms. Young, the cost would have been far less than the cost of this lawsuit and the damage to the company's image. Accommodations required by pregnant women are temporary and typically less expensive. As a woman and a mother myself, I do not understand UPS not allowing for adjustments in Miss Young's medically necessary work request. I agreed when Justice Breyer plainly said, "Why, when the employer accommodated so many, could it not accommodate pregnant women as well?" The wisest and the best course of business action is to make available the requested modifications.